Thank you all for staying with us throughout the end of the day. You certainly have earned your buttons, and if you haven't, then go outside and grab them. We have a really thought-provoking dialogue throughout the day, and I'm really certain that with the lineup on this panel, we will not disappoint you. I should say I'm Jill Bussey. I'm the Director of Advocacy at Clinic. And as our panel description indicates, our goal is to review several of the unprecedented policy positions the administration has taken that have effectively created an invisible wall around the United States, shutting down longstanding immigration and humanitarian programs, hindering the reunification of families, and reducing employment-based immigration. As we will see and we'll discuss, each of these immigration policies have significant implications here and abroad. Our panelists have a depth of experience in these policy areas and firsthand experience on the impacts. Our discussions in preparation for the panel, it's been abundantly clear to us that each of the policies we will discuss have proven to have detrimental effects on our global and national security, foreign and domestic policies, and economies, as well as the society. To provide you with the roadmap of our discussion, we'll start with introductions to our panelists. Together, they will cover a vast spectrum of immigration policy topics, yet each represent organizations or people who are bravely challenging and testing the limits of executive power. First, we have with us at the end of the table, Julie Kornfeld, Skadden Fellow and staff attorney with the International Refugee Assistance Project, or IRAP. She's going to share her perspectives on challenging the administration's efforts to halt and shrink the refugee program, as well as fight against the ban on entry to the United States by certain individuals from 8 countries. Next, we have Abel Nunez, Executive Director at the Central American Resource Center, or CARECEN, a leading nonprofit organization that has been providing a wide range of services in Washington, D.C., to the Latino population and beyond, including direct legal representation, housing counseling, citizenship education, community economic development. And he's served for CARECEN's executive director now for 4 or 5 years?
5 years.
5 years. And he has received Georgetown's John Thompson Jr. Legacy of Dream Award in 2017. Abel has been very kind to participate in today's panel with very short notice. As you'll notice, the ambassador of Haiti is not with us. Unfortunately, he was unable to attend due to unexpected circumstances, but he did send his regrets to us all. Finally, Rebecca Peters, who is with the Director of Governmental Affairs with the Council of Global Immigration and member of the Executive Committee on the Compete America Coalition, which is a leading advocacy group for reforming U.S. immigration policy for highly educated professionals and guarding against unreasonable enforcement mechanisms to critical visa programs. So we look forward to Rebecca's perspectives from her experiences, particularly the challenges U.S. employers are facing when trying to retain and find and retain the talent they need to fuel their businesses. One note on the panel as well, we tried really hard to have a DHS voice on the panel, and in all fairness to them, they really tried to. But in the end, we just couldn't make scheduling work out with our preferred speaker. As you know, we do try to aim to provide balance and a variety of perspectives on our discussions, and that's why we look forward to your thoughts and questions at the end of the panel. So, okay, with that, we will launch right in on the subject of the extent of the president's power as it relates to setting policy on who has access to the United States, either temporarily to visit, work, to study, or more permanently to reunify with their family or to seek refuge. So with that, we'll turn it over to Julie.
Great. Thank you, Jill. So before we dive into the actual policies, I just want to make sure that we bring to light the people that are affected by these policies, because in the administration's attempt to create this invisible wall, one of the effects is to keep those people that the government has deemed unworthy of entry to be invisible. So I'm going to start with a story. On January 28th at 2 a.m., I found myself pacing really, back and forth at Terminal 4 at JFK. My client, Mr. Haider al-Shawai, had landed 6 hours before that, and I had yet to hear from him. When the executive order was signed on January 27th at 4:42 p.m., Haider was in the air. He was on his way to be reunited with his wife and son after 3 years of separation. His wife fled Iraq after her brother was killed in a car bomb attack because his family was targeted because of their affiliations with the U.S. Army. Instead, when Haider was landed at JFK thinking that he was going to be reunited with his family, he was immediately handcuffed. When I hadn't heard from Haider and we were actually able to get confirmation that Haider was being detained pursuant to President Trump's executive order, a colleague and I rushed over to the airport. On the way over, Haider's wife called me in tears. This was the first time that she had spoken to Haider, even though he had landed 5 hours before. She told me, "Julie, they're going to deport him. They're sending him back to Iraq." So when I got to the airport, I immediately approached CBP officers and demanded that I get to speak to Haider. Meanwhile, a team of lawyers was working on a habeas petition challenging Haider's unlawful detention. In an unprecedented move, the Eastern District of New York held an emergency hearing that night at 7 p.m. At 6:30 p.m., Haider was released. That was the government's effort to moot out our claim. As Haider and I walked out of the JFK airport, we passed thousands of protesters, and Haider actually joined in with their chants, "No hate, no fear, refugees welcome here." As we got in the car and moved on to go to a nearby hotel, we turned on the radio and we heard that the Eastern District of New York issued the first nationwide injunction on President Trump's attempt at creating this invisible wall. So now I'll quickly go into how we got to where we are now. This first version of the ban had two parts. It had a refugee ban and a visa ban. And it was quickly struck by lower courts. The government decided not to appeal, and it just rewrote the ban. In the new version of the ban, it removed all references to religion, it removed Iraq, and it removed the indefinite ban on Syrians. IRAP, based off of the injury to the organization and our plaintiffs and our clients, we challenged this ban and we were successful. As we were working our way up to the Supreme Court, the ban expired. And then the government issued two bans to replace it, a visa ban and a refugee ban. We'll first talk about the litigation circling around the visa ban, and then I'll go back to the refugee ban and the government's attempts at lowering refugee admissions. So IRAP amended its complaint in IRAP v. Trump to challenge this new ban. It was an indefinite ban banning 6 majority Muslim countries. Our case was joined with Hawaii, and we made it to the Supreme Court, as you all know. And this is going to be a very oversimplification of our challenges, but given the time, and we can talk about it in more questions and answers, we basically alleged both constitutional claims and statutory claims. Our constitutional claims were that because the president preferenced or was specifically listed 6 majority Muslim countries, it was a violation of the Establishment Clause, preferencing one religion over the other. And our statutory claims were that the president used too broad of discretion in banning too broad of a group from entering the country. Ultimately, the Supreme Court ruled that we did not carry our burden to show that the ban was unlawful. And one of the reasons why the Supreme Court reached this decision was they thought the ban had a national security interest because of its focus of waivers. The ban said that if an applicant was denied a visa and would suffer undue hardship, they can get a waiver. So this is where we are right now with the visa ban litigation. There's this whole new wave of advocacy and litigation surrounding this waiver process. And the thing is, this process is really, really opaque. At the time of oral arguments, only 2.5% of these waivers were being granted. But since then, IRAP has been able to obtain documents through a FOIA request to give a little more background on the visa waiver standard. And these documents actually suggest that the bar for getting a waiver is much more high than the government intended. So right now, we really have no idea how many people are waiting for waivers and how many are being approved and how many are being denied. So this is really where the crux of the next legal fight is. It's on an individual level trying to obtain these waivers, and it's also in efforts through litigation to force the government to clarify and implement this waiver process. And then obviously there's general advocacy trying to get at transparency and more of these waivers. Now I'll circle back to the refugee ban and the larger trend of lowering refugee admissions. The president announced the latest version of the refugee ban in October of 2017. This proclamation suspended refugee applicants from 11 countries, 9 majority Muslim, for 90 days, and it indefinitely suspended refugee family reunification. On behalf of our refugee clients, like Jane Doe 4, who's a transgender Egyptian woman trying to get her degree in Cairo, who is unable to go to university because she'll be killed because she's trans, IRAP filed a lawsuit, JFS v. Trump. We were successful in obtaining a preliminary injunction and joining the enforcement of this ban in part. And right now, this litigation is ongoing. We're currently in discovery, and we're obtaining documents through discovery that show the administration's attempt to ban refugees now without an avert policy through these backdoor practices. And what they're doing is they're sending these refugees back through the security checks. They're making all the refugees of the countries listed start at square one, and then they're also adding additional security checks. While this may seem like a small delay in the process, this actually has life-devastating effects, and it can result in a life ban. Because in order for a refugee to come to the United States, they both need all their security checks to be valid, as well as their medical checks. And if they expire, then the whole process has to restart. On top of this, the president has further reduced U.S. refugee admissions. I believe the USCIS director spoke about this earlier this morning, but 2 weeks ago, the president set the presidential determination at 30,000. Whether this is going to be in effect or not is still, we'll wait to see. But it's a historically low number. This is a significant departure. The last administration, the ceiling was 110,000. And this has effects that can reverberate around the world because as the leader in refugee admissions, other countries are going to show that the U.S. has closed its borders to refugees and might do the same. So as we forge ahead in light of the SCOTUS decision, as well as the PD, there's a couple things to remember. One, it's not just about the court wins. We've had varying success in challenging these policies, and litigation has the effect, win or no win, of elevating the individuals affected by these invisible policies and bringing their injustices to the forefront. Two, litigation is just one tool. One of the reasons why this resistance has been so visible and effective is because of the combination of lawyers, protesters, journalists, policy, Congress. We're all working together. And it's this unique combination that is working together to attack this invisible policy. And lastly, it's not over. The best advocacy is tied to these grassroots work. That's why we've been able to see these policies and act early. We have been able to see these policies, and they're not always coming down in the name of executive orders or presidential determinations or proclamations. We're able to see weird trends like a vast majority of Lautenberg denials, for example. And it's because we're on the ground that we're able to then call out the lawyers, call out the policymakers, and really challenge these policies. Thank you.
Thank you, Jolie. In the interest of time, I think we're going to move along the panel, and we'll add questions at the end. It really has been gutting to see the impacts of these policies, these very harmful policies, particularly on refugees, at a time where we are at a height of a global crisis here. From the perspective of refugee resettlement agencies, which are within our network as well, the receiving communities' perspectives, the financial and emotional harm that's done, we commend IRAP's work and thank you for that. We have seen multiple office closures of refugee resettlement agencies and reductions in staff almost across the board. So it doesn't just have an impact on refugees, but also those who staff those agencies here in the United States. Not only is the current refugee policy wholly inconsistent with what we've seen in past practices, it's wholly inconsistent with international practices that call upon us to not return individuals to countries where it would be unsafe and harmful for them to return. And that is why in 1990 the Congress created the TPS statute. It's based on a similar principle of refugee law that is non-refoulement. We promise not to send people back to their deaths. Abel, we've seen quite a bit of change in terms of the decisions with TPS, which is a humanitarian form of relief. Since 1990, 20 countries have been designated for TPS, and currently there are 10 countries that are designated. However, 6 have been terminated in just less than 2 years. That will leave well over 300,000 TPS holders without their current protection from deportation and the work authorization that they need to sustain themselves and their families. Many TPS reports have been out, and they show that TPS holders are well rooted in our communities. Many have been here for decades. They have hundreds of thousands of U.S. citizen children, very high rates of participation in the workforce, and many are owners of small businesses, and have mortgages. They also send pretty life-sustaining remittances back to their home countries that are marked by high rates of those countries are marked by high rates of unemployment, underemployment, lack of infrastructure, housing, high rates of violence and public safety issues. So we're hoping to hear from you, Abel, on your experience as an advocate. You and I have met with DHS leadership and policy officials before each of the Central American and Haitian decisions. During these meetings, we heard their perspectives and focused on the temporary nature of the statutory provision and the new position of their policy, which has now taken on this new and unique interpretation of the law and review of country conditions. So I'm interested to hear from you about how the administration has justified its terminations of TPS and how TPS holder plaintiffs, there has been litigation. How are they challenging these decisions?
Thank you, Jill. Thank you, everyone. I would like to start by saying that, as the flow of immigration is changing in this nation from one being primarily a Mexican adult seeking employment to Central Americans seeking refuge, I don't think the nation is ready with its legal framework to address it. we look at things, how Central America has played a significant role in our immigration laws and the way it's adjudicated, from the ABC class, TPS, 1990, that protected Salvadorans originally, NACARA, the Flores Accord, which is a Salvadoran young woman, the Caravan, that was a Honduran, primarily people coming north, and other things that were mentioned, like the Attorney General Sessions decision. It was a Salvadoran woman whose case was adjudicated. So I think that we have to be clear that there is a particular sort of area of the world where this is happening. When you look at TPS, the largest groups are, when you add Hondurans and Nicaraguans, a smaller group, but Salvadorans, they make up over half of all the TPS beneficiaries. But interestingly enough, the wall that's being created is actually much more effective than any physical wall that could be created at the southern border, right? Because if we really look at it, there has been no new legislation introduced. This has been done by the administration with its authority to do it. And as we met with Secretary Nielsen, they were not necessarily being creative in how they interpreted the termination of TPS. They were just narrowing the scope, right? Because they basically said, first of all, it's temporary. People, from their perspective, they are protecting people so that they will not be beholden to a process where every 18 years they have to pay fees and do it and continue to do it indefinitely. But they also were very clear that the statute for them locked them into a position where it can only be extended if the original conditions by which the initial TPS was granted still continued in the country of origin. And for countries like Honduras, Nicaragua, El Salvador, where it was an earthquake and Hurricane Mitch, we could technically give an argument, but it wasn't a clear line from that. Now, I think the other piece of information that we should also know is that because of the work of the Foreign Relations Committee, we now know that the advice that they received on the ground from the consulates in the countries of origin were to extend the status, right? But they chose not to. They chose to narrowly view the statute and render their decision. And I think I heard in the panel before us that it was just about causing pain, right? It doesn't really make sense for it to do it. Now, Secretary Nielsen was very clear to us when we met with her that the only body that could fix it permanently is Congress, and she is correct. But I think, as we heard throughout the day, given the current situation that we're living in a polarized sort of environment, that is probably highly unlikely, at least in the near future. So much so that when we were there, she committed to us that she would do lobbying with us. She would go on the Hill and promise us that she will walk the halls with us and ask our legislative body to pass laws. And we'll see if that's the case. We'll call her up on it.
Have you seen that happen yet?
No, I'm still waiting for that.
Okay.
Maybe after the elections. But I do
sure
think
it's
that one of the other remedies that we have relied on is the courts. Given that the legislative body is unable to provide a permanent remedy, we have an administration that has taken the decisions that they have. Our only recourse has been the courts. And right now there are 5 class action lawsuits to prevent the termination of the status. Now, I have to say that this is not a permanent fix. So we're not necessarily the suits, and correct me if I'm wrong, but they're not challenging the authority of the president to take action. It is in the way in which the action has been taken that has been, based on racial profiling or against communities. He, has given us some of the recordings about what he thinks of countries from Haiti, El Salvador, and some African nations. That is the basis why some of these suits are there, or the harm it would cause to citizen children of TPS parents and the decisions that they're going to have to make when they lose their status and have to be returned to the country of origin. So they have left a very narrow way in which we can resolve the situation the last thing I would like to say to that is that even when TPS was passed, it wasn't the perfect solution. It wasn't like the advocates at the time, that was their end game. It was sort of what you could get at the moment. And I think, as an advocate, you get what you can get when you get it, and you continue fighting on until you have a better landscape that allows you to get you more. And I think that that's what TPS proved, is that the landscape actually has not gotten better, it's probably gotten worse, but we will continue the fight. And I think that the lawsuits currently in the courts is about giving us that space, that time to continue working with the legislative body to ensure that we can really get a permanent fix, and hopefully with the help of the Secretary joining us on those congressional visits.
That would be lovely. And just to clarify, I would love nothing more, really. To clarify for those in the room who are not familiar with the TPS statute, the reason why we're looking for a permanent solution through Congress is because the TPS law does not allow an individual to apply from TPS to green card. There's no direct path there. That just is wholly a flaw in the law, if you will. So that makes me think about Director Cisna's earlier remark this morning that, that there's options for TPS holders, yet I'm not sure without that direct path. Abel is the executive director of a nonprofit organization that provides direct legal services to TPS holders and their families, as well as counseling employers who value those workers. What are those options, all those immigration options that the director was referring to this morning? What are those alternate immigration options for us?
So Director Cisna was, correct in saying, are there paths for the TPS class? And I would say yes, but when you look at the original number of people that were in the program, Salvadorans particularly, about 275,000 were part of the TPS status after the earthquake. Currently, there are about 190,000. That's a 30% drop. Some of it has been because there's a natural transition that people do not register for multiple reasons at every registration period. But some of those reasons is because they do find ways to adjust through family petitions, work petitions, or other mechanisms. But the reality is that the majority, after almost 20 years, if there was a clear path, the majority of the class would have already been, had their legal permanent status. And so the reason people don't choose to stay in TPS and not go for legal permanent residence if they have a choice. The reality is that it's very limited, and we know, we're in this field, that the path, and I will admit that yes, this country has one of the few countries where you only have to be a family member to be able to reside legally into the U.S. And I count myself as part of that, because I'm part of that flow. I'm part of the family migration. I was lucky enough that my aunt was a citizen, came here in the 60s, and in the 70s petitioned her brother, my dad, and so we came. So yes, so I'm not saying it's all bad, but it's limiting. So particularly for a group of individuals that didn't have any family connections and now have lived here, and the family connections that they may have don't have the ability to petition them. Mm-hmm. So though the director may say that, yes, by law, the statute states that under TPS you can apply for other benefits if you're eligible, the problem is that there are very few. So we estimate that about, out of the total class, and this is a total estimation from what we see in our offices, that 20% may qualify for something, a family petition. 20% are probably excluded because they had an order of deportation or other matters that would prevent them, and once they lose the status, they become more vulnerable to deportation or immediate deportation. But the remaining don't really have an option. And when we heard the panels, and I don't want to go over this because I think they spoke on it better, in terms of asylum and how they're trying to reduce, not accept domestic violence or gang violence, which is what a lot of the Central American TPS holders could use as a basis for a credible fear in an asylum case. The options that are there, which are limited, are becoming smaller and smaller.
Thank you. I think if we could just very quickly talk about one of the last implications of the TPS decisions, and I think that will tee up Rebecca's next comments. In the DC metro area, we have the single largest population, I believe, of Salvadoran TPS holders. And in fact, our mayor, Bowser, here in DC recently visited El Salvador to San Salvador and a very small village that uniquely most of the TPS holders here in the DC area originate from. So it was a way of circling back, and I think acknowledging the amount of work that Salvadoran TPS holders do to, number one, build DC. Many TPS holders are in the construction, literally building DC. Many TPS holders in the construction industry, but also by sending remittances back that are developing El Salvador and contributing to the development of the economy there. So when TPS turns off next year, September next year, what happens to our respective economies? Here in DC, a construction industry that relies on these very essential skilled workers, and at home where there has been this tremendous need for development.
Yeah, so, the TPS beneficiaries are hyper-concentrated in certain communities in the U.S., LA, the D.C. area, Boston, and other places. But they're also hyper-concentrated in certain industries like construction and hospitality. So in this area, 20% of all construction workers are TPS beneficiaries. At a time when there's a lack of workers for the construction trade, they can't find workers right now. In September 2019, they will lose a significant size of their workforce. And these are not laborers. These are skilled workers, because most of them have been with the companies for many years. The companies have invested heavily, so you're talking about foremen, you're talking about machine operators, people that they cannot replace overnight. You have situations where, I spoke to a vice president of HR for one of the big companies here in the area, and he told me, I go to job fairs all the time, and if I find 5 employees that I can hire, that's a lot, he says, and then they last 2 days. The reality is that the construction trade is a very dangerous place to be, so much so that new employees, actually, a lot of companies put them special hats to let them know that they're newbies, so that the other workers know that they're newbies, because they know they're going to make mistakes that can actually get them killed. And that's what he told me. He said, the construction trade is one that if you don't know what you're doing, you can actually get killed doing that job. And so what happens to industry here, particularly given that the construction industry, because of the majority of their contracts come from the federal government, use E-Verify. Mm-hmm. So when that happens, they told me, unfortunately, that we're going to have to terminate all of those employees. And they don't know what to do. They were... one of the companies here was willing to fly all the TPS members to California because they heard of a decision by the Ninth Circuit that they thought that they could send them there and they were going to get legal permanent residence, and we had to explain to them, well, it doesn't really work that way. And but if you think of a construction company willing to send 20% of their workforce, house them, give them jobs while they're waiting for this, that is how much they're willing to do it. And they're willing to do the individual defense, meaning the labor petitions, but that's just not going to cover it. It won't work for all of their employees. So I think that we will see what happens in this local area and the local economy. The thing is that the U.S. economy is so large that to say that the TPS will topple the U.S. economy, that's never going to happen. But what is going to happen at the micro level? What's going to happen in the D.C. area, in Los Angeles? And, this is an area that depends much on its own development on the construction and the hospitality, right? So we're looking at where is this workforce going to come from. The danger in that is that because most TPS members, when they lose their benefit, will not leave, it means that they'll go into the shadows and they'll be more susceptible to abuse. They'll be hired and served directly by the company, by subcontractors and of subcontractors. And then, they'll be really vulnerable. And so I think that not only are we going to have to protect them and try to get them protection in the immigration field from a collective protection to individualized, but now we have to also protect them from housing abuse, from labor abuse, and from every other abuse that most of the undocumented community now faces. Because remember, this is a community that has been legal for close to 20 years. And so they have driver's licenses. They're really well integrated into the community. And so now they have to sort of uncoil all of that and figure a way, what's their next step? Do they leave? Do they stay? And if they stay, how do they stay? And I think that that's the challenge that's before us.
Thank you, Abel. I think that relates well and transition us well to Rebecca's part of the panel, which is really the employer's aspect and perspective, not just the loss of TPS, but the insecurity with DACA, the scrutiny of employment-based applications. So Rebecca, I want to turn it over to you and we'll watch a quick video.
Sure. Thank you, Jill, and good afternoon, everyone. Our last panel today. I just want to make sure that I thank MPI, Georgetown, and Clinic for what I think has been a great conference today. At my employer, SHRM, the Society for Human Resource Management, we've recently launched a global conversation on the workplace, where we are looking at 3 issues that we believe will impact the future of work. Closing the skills gap is one of them. Modernizing our employment system is another, and preventing workplace harassment. Obviously, those first 2 issues are critical to our discussion up here today. And at SHRM, we've actually begun to have this global conversation on the workplace by airing content on cable and digital networks across the country that feature our CEO, Johnny C. Taylor Jr., interviewing HR leaders at leading companies to really share with America the people management perspective of how these issues are going to impact the future of work. And last week, actually very well timed, unbeknownst to us with this conference, we happened to launch our Modernizing Employment Immigration video. So we wanted to share that up front with you before I launch into my opening remarks. So could we share that, Lisa?
We live in an extremely competitive environment, and everybody wants the best and the brightest from wherever they happen to be on the planet. So when you think about immigration is not a U.S. issue. It's not an issue of borders. Business has no borders.
I'm Johnny C. Taylor Jr., President and CEO of the Society for Human Resource Management, SHRM. We're engaged in some deep and critical conversations around issues impacting the workplace, including workplace harassment, immigration, and the skills gap. Join us for these amazing and engaging conversations with America's HR executive leaders. We are at one of the few times in American history where we have more open jobs than we have Americans looking for jobs. This is about making sure that American companies in particular can grow. Talent is what's going to be the difference between the companies that win and companies that don't.
It crosses the entire spectrum, so it's an immigration issue, but it's not either or, it's a both and. It's really about finding the best and the brightest, bring them together to solve the world's most difficult problems.
The employees that you ultimately are going to bring into your organization to win at John Deere come from everywhere.
They come from everywhere. We are an iconic brand, but we're an iconic brand that does business around the world. And having HR professionals who understand that is critically important.
SHRM, the Society for Human Resource Management, has to make sure that we have skilled up the HR professionals to compete in a global environment. So SHRM developed certifications. There are certified HR practitioners, just like there are certified financial accountants. We know that individuals have to have the capability to practice good HR.
It's critically important. We have to think, what will the needs of the business be in the next 5, 10 years? And what are we doing to create the workforce that we need to have in the future?
The companies that will win will have gotten the people issues as right as the business issues.
So I hope you all could hear that. I think the point here is that as we embark on a global conversation on the workplace at SHRM, because we are a policy solution-oriented organization, want to discuss really three important issues that we need to discuss and also solve as we think about the future of employment immigration, even amidst this invisible wall that we are talking about on today's panel. And the first of those is closing the skills gap. I think everyone in this room is very aware America faces aging demographics. At SHRM, we've surveyed our own members, and we found that nearly 7 in 10 HR professionals face difficulty filling full-time positions in STEM fields. We know from other leading business stakeholders like the Business Roundtable that nearly half of CEOs face talent gaps and find them to be problematic or very problematic for their companies. You couple that with what you heard in our video, where we have ultra-low unemployment, more open jobs than individuals unemployed, and we're really in a situation where employers need to be doing everything they can to not only educate, develop, and really upskill our workforce, but also looking to invest in the U.S. worker talent pipeline. At SHRM, we like to talk about the 2 E's, education and employment. And this is really talent development, right? Something that our employers are doing on a daily basis, whether it is upskilling an employee because of failures of our K through 12 or K through 16 system, or if it's needing to address these issues with the skills gap in STEM fields. Whatever the case, we take it to heart at SHRM because actually over this summer, we were a part and we went to the White House with dozens of other companies and leading associations to sign a pledge for the American worker. And we at SHRM pledged to upskill 127,000 HR professionals over the next 5 years. And I think as we look to closing the skills gap, you know, immigration is one of the issues that factors in, but we also need to make sure that we're hiring our veterans, our disabled, the formerly incarcerated, and the unemployed. So that brings me to kind of the second issue, right? Modernizing our employment immigration system, which I think, as we think about it, needs to be front-looking towards the future of work. And this is something that I've actually been saying for the nearly 2 decades that I've been advocating for immigration reform. But if we get to the gist of it, what we're really talking about is if we want U.S. employers to be the best in the world, which we do because we're America, right? We want the best. Then we need our employers who are facing these skills gaps to have the ability to access the foreign national talent they need no matter where they reside in the world, because no one country has a monopoly on talent. And so as we think about how we need to modernize our system, you know, there are some critical things. One, we have to clear our green card backlogs so employers can retain employees. We also need to ensure that compliant employers, those complying with our immigration laws, have the ability to access the talent they need. We need a system that is efficient and predictable for business. And we also need the ability for employers to have the tools to hire a legal, L-E-G-A-L, legal workforce. I want to share just 2 examples quickly, Jill, if I could, of where we are facing really kind of difficulty in accessing talent. One of those is in the last 4 weeks, and I'll use the H1B as the example, the H1B visa. Many of our employers have had difficulty with the current suspension of H1B premium processing. And in fact, we've heard from some of the law firms that we talked to that nearly 25% of their clients have not even had a first touch adjudication-wise on the H1Bs that were filed back in April. If you think about today, today's October 1st. It's actually the start date for new H1Bs. And we actually, because of this suspension of premium processing, have a lot of employers that are going to have to take certain individuals off their payroll. For instance, students that graduated, last spring, who were set to start today, who now cannot be processed in time because of the premium processing suspension that they were not exempted from. I also want to mention some other H1B policies I think that have been extremely challenging for employers. I know everyone in this room remembers last April 2017, President Trump put forward the Buy American, Hire American executive order, which is something that the federal agencies have been implementing over the last year and a half. And during that time, there have been handfuls of policies put forward around H-1B visas in particular. But we have, for example, situations where some of our employers are hesitant to actually file for H-1B portability, which is one of the ways in which our employers access the best talent, right? Because they can say, hey, employer A, you have a great talent over there, and I'm going to make them an offer and bring them over to my employer B work site. And they can do that before, under our laws, they can do that before the H-1B petition is approved. But given recent policies that the agency has put forward, employers and employees are hesitant to do that because right now an H-1B can be pretty much flat out denied, much more so than it could, even 6 months ago. So if that happened, you would bring someone on board who then immediately has no legal status, right? And then there's the concern with recent policy out that at some point in the future, this individual could be issued an NTA. Now, I know the NTA policy that was put out recently exempts petition denials like the H-1B, but what we don't know is if at some point in the future that could be a situation where they'd be issued an NTA. So the point is, employers do not make decisions based on uncertainty, right? They make decisions based on predictability. And the only predictable outcomes in this situation are to wait 6 to 8 months for an H-1B. We know business moves much faster than that. If you happen to be a multinational employer, which many of our employers are not, by the way, but if you happen to be, maybe you could take that employee and move them to a location overseas that's one of your locations, or you could just hire an employee overseas. But I think any of those alternatives really do not bode well for America's competitiveness or for our U.S. employers to actually be able to innovate and job create here at home. The last point I'll make, Jill, and then we can get back to the panel discussion, is if we really want to do our best to protect U.S. workers, then we need to have our federal government enforce our laws against bad actors and not employers who are acting in good faith. I think given the H-1B example I shared with all of you, employers know that that policy is being put forward to protect U.S. workers, which we fully support. Our employers hire many U.S. workers, a majority of U.S. workers on their workforce. So we want to protect U.S. workers. But we can't be hurting legitimate immigration law compliant employers in the process when they need to access other talent because they face these skills gaps. And I'll give 2 examples actually to the agency's credit where we've actually seen them enforce laws against bad actors. Recently, and this was based on a recommendation from SHRM a couple years ago, we asked them to really focus their FDNS site visits on bad actors, which we understand from the agency they've started to do this year. And the other example I'll give is we, over the last couple of decades, have put forward a concept of a trusted employer program. This is a concept that is in bills, both in the Senate and the House this Congress. But at its core, it is really one that says, hey, if you are a compliant employer, you should be able to actually file information that is commonly filed with the agency once up front instead of multiple hundreds or thousands of times. What this does is it creates efficiency and predictability at the agency, saves resources, but it also helps flag compliant employers. So I think there's a lot we can be doing solution-wise as we look at the future of employment immigration, even amidst this invisible wall, Jill.
Thank you, Rebecca. Insightful. I know that you weren't able to be here for Director Cisne's remarks, and I thought you might find quite interesting that he definitely committed to modernizing the immigration system all the way up to the 1990s. So I'm sure that your colleagues at SHRM will be really grateful to hear that commitment towards modernizing. Truly, the predictability of USCIS is, at this point, processing backlogs across all product lines, not just employment-based petitions. We've seen a tremendous backlog in TPS applications, other applications including naturalization, which can impact U.S. employers as well, U.S. employers who require U.S. citizen employees because of certain requirements, particularly here in the D.C. area where we have Department of Defense and other employers who require U.S. citizen employees, right? What happens when we have a naturalization backlog that is now going to take someone maybe 2 years to get to attain citizenship. So I do think that, again, your colleagues at SHRM will be happy to hear there is predictability in the backlogs, and we can look forward to the modernization to the 1990s. I won't say anything about the Supreme Court hearings there. Leaving it at that. I would love to hear from you all. This is the end of the day. We'd love to hear your questions. We have just about 20 minutes left to the panel here. So I'd like to entertain questions from the audience, and we hope that the mics are on and queuing up would be ideal. I see one person moving up to the, and then I may use a little moderator privilege and ask some questions. Ma'am, if you'll identify yourself.
Hi, Karen Anderson. I'm the interpreter on the immigration cases. My question is for Rebecca Peters. Does your organization and its advocacy focus solely on employment categories that are traditionally the higher skilled ones such as STEM, or do you also focus on some of the work categories that are shortage areas where immigrants are often a large part of the workforce, such as health care for the elderly?
So thank you for the question. Yes, great question. We focus on everything worker and workplace. So we focus on both the essential workers, as I think you were hinting at, as well as high-skilled workers. And, you know, I think one of the recent policies that will possibly impact maybe the essential workers more than the high-skilled workers, just to give you an example, is the public charge rule that we heard the director talk about this morning. I mean, obviously, we won't know until we see a final rule if that is the case, but when we look at the standard that the last panel was talking about, the totality of circumstances standard, I think it's the evidence that would come before the adjudicator, whether it be education, skill, or, you know, I think they're also looking at past credit history, bad credit history. But I think that probably bodes a little bit better to a high-skilled worker if they have an offer of employment where they're getting, you know, paid a higher salary potentially than an essential worker.
Hi, my name is Anna Gallagher. I'm an immigration attorney. I practice here in D.C. at Maggio and Cater, and I have a question for Mr. Nunez. I am counseling, as probably many immigration lawyers in this room are counseling folks with TPS right now, trying to figure out what they'll do when it ends. And some of the options we discussed are asylum, and then subsequently cancellation of removal. So my question to you is, in your meetings with the White House and with Secretary Nielsen, did she or anyone else in the White House express any concerns about the potential backlog of thousands of asylum cases that could be filed, and then the subsequent referral of thousands of cases to the immigration courts to seek cancellation of removal? And would that be something, I mean, it's certainly not, I'm not suggesting it's a tool to negotiate, but it's a reality. Is that something that's being discussed in terms of encouraging, urging Congress for reform? Thank you.
Yeah, thank you for the question. It's a little bit complicated because as we're moving away from a collective protection, the only option is individualized protection. But there are some challenges because as much as, and thank you for the work that you're doing in terms of seeing and counseling TPS beneficiaries, but the reality is that the field does not have enough lawyers at this moment to cover everyone, right? And even if we can see a model where we can do pro se, affirmative asylum applications, when they get rejected and sent to court, to send, TPS beneficiaries alone at the court system is to have a bloodbath for those people. So that one, we have to elevate our capacity to serve individuals. But two, I do think that we have to be clear about the administration. With every intention, they knew what they were doing because they're five steps ahead. So if we think about the limitation of what a credible fear is, the ability of turning around the calendar, those were already things that the administration has done to prevent or at least be thinking about what our reaction was to the termination of TPS. I think they were very clear that for us, asylum was going to be a avenue to protect these individuals, and so they are really souring the milk, right? They really want to do it for that, but they knew they want to make it as difficult as possible for individuals to choose that path. Not to say that asylum by any means is easy, particularly for a population that has been here for a long time, and there are other, one of the things that I asked them specifically was, would given the fact that TPS in the statute says that it resets the clock on your asylum time, they basically said that, well, whoever was here for a year already, prior to coming into PS will be denied. And that has been the case. We have actually 2 cases at CARECEN where they've been denied on that grounds that their year was up because they were here a year prior to coming into TPS, and TPS did not reset that clock. Which I've mentioned back to them, it's like, well, I guess we'll see each other in the courts because INS and, USCIS has a history of battling it on the courts, and, look at the Flores Accord, look at the ABC case. Those were cases where they had a perspective. We had another one, took it to court, and there was a settlement done, right? And so right now the courts are our best friends, so there's going to have to be a real thinking about what it means to protect them individually. Because the reality is that the countries of origin cannot absorb their nationals, cannot reintegrate them. They can maybe receive them, and they'll tell you that, yes, we can receive our nationals. Doesn't mean that they can integrate them. And so, and given the fact that we have blended families where you have citizenship children, they have roots, just taking all of that back to your country of origin is not easy for folks that have lost their social networks in the country of origin, do not understand the current realities of that. And I would finally have to say that, the administration, in particular this president's strategy, is to shake things up, right? Because that realigns the way we do, whether it's world trade, whether it's immigration. But in that chaos, illicit actors also thrive, right? And we will see people being pushed into the shadows, because even in the way they did the TPS extension, we have people that still have not received their work permits. And because it interacts with local municipalities, they can't get their driver's license. There's a whole things that they're prevented to do in the way they're actually processing the current TPS status. So I think that as we get to the final date, we will see, are they going to get NTAs? They said they will not do that, but I think we need to, as a community, need to be ready for that and what's going to be our response.
Yeah, I would, thank you, Abel. I'd add to what you said, 2 things. Completely failed implementation on the TPS terminations that we've seen so far from our network's perspective. We had a lot of daylight between the announcements of the TPS decisions and when the actual Federal Register notices were published, and that's really the instructions that people need and legal representatives and employers need in order to figure out how to comply with that decision. 56 days it took them from announcement on Haiti to publication of the Federal Register notice. We've seen 20,000 Salvadoran TPS holders recently who were impacted by processing delays in their cases. Their cases were not processed within 6 months, and then they were subject to this whimsical auto-renewal that wasn't published in the Federal Register. Employers are having really difficult time trying to figure out what to do with the I-9 requirements there. apparently E-Verify was not updated quickly enough in some cases, and so then the SAVE system was not updated, so we have issues with re-verification of employment, and of course the driver's license issue, which can really be quite detrimental for an individual, particularly in some jurisdictions. So really failed implementation, which is ripe for and provides us with an environment for litigation. I think we saw that IREP, I think, has been able to tease out where failed implementation gives us those opportunities. Of course, that doesn't take away from the harm that has been done. The other thing that I would add to this is not only do we as immigration legal services providers not have capacity to handle just the TPS population, now add DACA to that, that's over 1 million people who may be losing their status. We don't just have enough capacity to help them on their immigration cases. Think about parents who need to figure out what's going to happen to their children. Family law, right? Guardianship. What about property? 30% of TPS holders have mortgages, so there's a high rate of mortgage and property ownership amongst DACA recipients. So immigration legal services providers are not, we're not general practitioners here. We can't do it all. I'd love to do that. No, I wouldn't. 20 years of immigration law is enough for me. But there's a lot of disciplines, right? That there's employment discrimination associated with these cases. So as if we still have law students in this audience, please let us retire at some point, get out there past the bar. But really, there is going to be a tremendous need to the community, not just in the immigration realm, but in other aspects of adjusting to this new life as an undocumented individual. Sir, you've been waiting patiently as I took my moderator privilege.
So my name is Jonathan Goldman. I work at the Right to Immigration Institute, which is based in Waltham in eastern Massachusetts. And your point right there actually led right into my question. So what we do is we train undergraduate students similar to a law school clinic model, and we have them work alongside with our staff of attorneys. And we've received sort of mixed reactions to having undergraduate students versus graduate law students following that model. But as you were just talking about, and as I've heard this year, and I remember last year in all the panels, is this talk about not having enough representation out there, not having enough high-quality representation. So I have a sort of a two-pronged question that I'd love to hear all your thoughts on. Or one, there's only so many students that are going to radically enter the law field and are going to continue doing this. So do you have other ideas of how we can address underrepresentation? And the second thought is I'd love to hear your guys' ideas also on focusing how we tap into potential, for example, on the undergraduate level as well as the graduate level, to have people train and work with all of us in this field.
Great questions.
Well, I would say first we need resources in the field, right? And the resources can come from multiple areas. So for my organization, one of the revenue streams are fees. We charge fees for our legal services, right? So that is the actual applicant or beneficiary actually putting, some of their resources. But that's already been done, or we'll continue to do it. I think that the newer thing is to have municipalities kick in with some money. We see New York doing it. We see San Francisco doing it. DC does it. And I think in friendly municipalities that understand that these are vital residents in their jurisdiction is to have municipal governments pony up and give organizations so they can staff up, because we cannot rely on the pro bono model, right? I mean, I think I welcome it and I thank the legal community for doing it, but it's not going to be enough, and we actually need to compensate and create our own legal service providers. And in terms of other revenue sources, some of the countries of origin. These are their nationals that they are threatening to deport back, that they have no way of actually integrating, and are actually a vital source of remittances back, which helps their gross national product. So I think that we need to really think about what are creative ways to bring resources into that, and to have real different partnerships with schools and figure out that process. I'll defer that to Clinic, who is our technical assistance on things that are actually the practice of law, which is technical, and don't want to speak to that, but I think for us, we need to make sure that there are resources available so that we can do our work.
And I'll just add, IRAP, one of our missions is obviously to provide free legal assistance to refugees and persecuted individuals, but a second prong of our mission is to educate and form the next generation of human rights and immigration advocates. And the way we do this is both we have 31 law school chapters around the US, Canada, and the UK, and it allows law students within their first year of law school to actually get to take on one of our cases under the supervision of a supervising attorney. And that's how I'm at this panel right now. I got involved my first week of law school, and I just came back from our student summit where we had over 200 student leaders, all law students, in New York, listening to Ambassador Samantha Powers and talking about the refugee crisis and what they could do with their legal skills. But I hear you that it's not just enough to have lawyers. So in addition to our law school chapters, we do have some undergraduate students working on these issues. One of the things that one of the processes that I represent many of my clients in is called the Special Immigrant Visa Program. And like the name implies, it's a visa program, and so it's extremely document heavy. And in order to be eligible for this visa, you have to show that you have faithful and valuable service for the U.S. military, you're Afghan or Iraqi, and as a result of your work, you're now being persecuted. And so the largest hurdles in accessing these visas is the inability to get these proof of documents from former human resources and former U.S. supervisors. So we actually utilize these undergraduate students, utilizing their amazing social media skills and Facebook, Instagram to track down these former supervisors to find these letters of recommendations. And through that, they see the challenges for the statutory requirements for this visa and start advocating on their college campuses and in their larger community. So I hear you, and IRAP is doing what we can, but I definitely welcome more ideas and to continue to promote the next generation of immigration and human rights advocates.
We have 3 folks in line for questions, so we're going to ask you to, and Rebecca has a quick response on this, we're going to ask you to present your questions, and then all 3 questions, please, and then we will try to address them as we can, but that'll be the end of our question and answer at this point. Rebecca, and if you'll just think about succinctly your 3 questions.
Yeah, I just wanted to quickly respond to the other question. I mean, I wanted to add beyond pro bono, and I think it dovetails off of what you were just saying, Julie, is another option as a student, as a law student in particular, is to get involved in advocacy. And at our organization, SHRM, we actually do have students that can get involved with our 535 chapters across the country. We have 10,000 members strong in our advocacy team. So if there are issues that pop up on the Hill where we need to actually move legislators in a certain direction, we activate our A team, and they come up through our grassroots. So I just want to say the other side to doing pro bono work is to get involved in advocacy, and one day you can, be a federal lobbyist like us.
Please, sir.
Hi, my name is Xavier Francis. I'm an attorney at the Erickson Immigration Group, and I specialize in employment-based immigration. Rebecca, there's a strong rhetoric in the media that foreign nationals are here to take U.S. jobs, and how can we better educate the public and our government officials that, as the video said, they're here to, we're here to make the country more competitive and to fill a skill gap, not necessarily to take U.S. jobs, and that actually immigration law is heavily regulated, perhaps the most regulated legal field. In what ways can SHRM further advance that education to the public and to government officials?
Thank you for that question, ma'am.
Hi, Heather Stewart from NAFSA, the Association of International Educators. The premise of this panel is that it's an invisible wall, and one of the horrible but good benefits of the visa ban and the Muslim ban was that you could physically see people at the airport. You have people speaking on TPS and employment. How do we make that invisible wall be seen as more visible to a broader audience, to be able to make the impact that needs to be made to make the changes that are necessary, so there isn't a wall, imaginary, invisible or visible? Thank you.
Thank you.
Hi, I'm Laurie Covert, Catholic Charities, Harrisburg, Pennsylvania. I'm just wondering what your ideas would be for, I wanted to say fix, but how about just improve agricultural worker programs in the U.S.?
Okay. Rebecca, did you want to start with, in response to the first question? I think Abel could address making the invisible wall visible, potentially. I think, Julie, I saw you nodding on that or wanting to weigh in, and then we can get back to, or did you want to wrap in the agricultural question?
However we wanted to.
Okay, go for it. Launch right in.
Yeah, let me answer the first question quickly. I mean, it's a great question. Foreign national workers complement our U.S. workforce, right? And I think in order to elevate that message, there are many things we can do. I'll use the lens of actually the DACA debate this year, which we haven't talked about up here, but our organization was heavily involved in. I think we still need good data in the debate, but I think we are kind of beyond data at this point, which is a little unfortunate, but given the false news or the fake news and everything we experience in a 24-hour news cycle, I think what's really, you've got to cut through that, right? And so you can cut through that by actually having the people's stories, the faces, the actual individuals impacted going to the Hill with you. I'll say I had a great experience in the first half of the year being able to go to the Hill to advocate with some of our members who brought DACA recipients with us, and they are quite a talented group working in cloud computing, HR, not owning just one business, but sometimes owning two businesses and employing hundreds of U.S. workers. And I think it's those stories we need to elevate. Having CEOs speak out is also, I think, extremely impactful. But we have to have the opportunities on the Hill to do it, right? And with DACA, that will come with the court cases moving forward and eventually possibly the Supreme Court looking at the issue. And when we get to a critical point where the court possibly could say, hey, the president does have the authority to do away with this program, I think at that point we have a window to actually advocate again on that issue in particular as the example I'm using. So I think there's a lot of opportunities to get out and advocate. SHRM is, one of those organizations. There are plenty around town that do it, not just us. And, happy to talk to you more about that. As far as agricultural workers are concerned, I think that's also a tough debate right now. There's a lot of divides. We had, I believe it was the most recent iteration of the Ag and Legal Workforce Act brought forward by Mr. Goodlatte in the House. And there was a lot of, let me just put it this way, there still needs to be a lot discussed and resolved and modified in that bill around what is needed around agricultural workers. But the long story short is that we want to take the H2A or H2A program to an H2C program, I believe, and really have the ability to access these people more so than we do today. And we need to find those opportunities, but we need to be able to work across the aisle to do that. So a lot of work still needs to be done with the egg solution.
Thank you, Rebecca. Final thoughts?
Yeah. We're in a very polarized society right now. I mean, I think that I hate to be a downer, but I think it'll be worse before it gets better, because we have to go through this process of understanding, the data is not doing it. We have data that shows how immigrants are good for this nation, strengthen our nation. So MPI produces incredible reports on the value of immigrants. But I do think that there's a segment of the population that's hurting. That I don't think means much to people that their industry is going away. Look at the coal industry. I mean, I can't go to them and show them a report that makes their life better. I think we have to be better at communications, of making sure that people had face time, because at the end of the day, it's easier to rail against numbers versus rail against individuals. And you see that because when you have in small communities, when they talk about, yeah, we need to build a border wall, but then when someone that they know gets deported and they realize, oh my God, this is what the policy is, it really brings it home to them. And we have to figure out ways how we interact. And it's not about, me going down there to tell them because they see me coming and they know where I'm coming from or what I'm going to say. I think it's about people, like-minded people, talking to other like-minded people. We have to go to the pews, we have to go to the schools, and we have to build it again, because I think that we are talking at each other and we need to talk to each other. I think that it's going to be a long process, but if we're able to do it, we will come out stronger. Because other than that, what we'll do is we'll may be able to pass policies, but with extreme friction that the other side will just be waiting until they have power to undo it, which is where we are right now, tit for tat. And so I think it's the long haul of making sure that all of us become vessels of communicating to our sort of closest network and telling this what it is, because all of us are here connected to other folks outside of it, and sometimes we are in our own echo chamber. We're inside the beltway, so that's how it works. But we need to get out of that and really just have conversations.
So quickly on making the visible wall invisible and the lessons we've learned from challenging the Muslim ban. It was the combination, again, of the lawyers, journalists, but also the anticipation of what we thought was going to happen. So earlier that week, we were released a draft of the executive order, and we actually sent out a call to our network of 100+ law firms and student chapters asking lawyers to sign up. Within like 2 hours, our Google form crashed because we had thousands of people sign up. And so when the executive order actually went into effect, we were able to unleash this army of lawyers at airports across the country. And so I think the point of that is that when we're talking about TPS and we're talking about these other issues, it's really important to be on the ground so we can spot these issues early, and then also expand our network so that we have this army of both advocates from the legal perspective, journalists, so that when things are happening, we can unleash this army. And we've seen this work not just with the Muslim ban. Our organization was in consultation with organizations over the summer, and for what was happening at the southern border, they did a similar response, and it was effective. And so I think it's really important to also not get distracted. This administration is challenging all different parts of immigration, and I think it's most important to just have communication between refugee advocates, between employment advocates, to share the best practices that we're seeing, but continue to stay focused on what you are an expert in and what you are passionate about.
Thank you very much to all of our panelists. I completely agree that we should not become discouraged or disheartened by the shock and awe of the administration, and together we can do it. I remain an idealist and optimist in that way, and seeing you all out here has reminded me of the many people who do really care about these issues. So we're really grateful for you staying a little bit later than 5 o'clock to accommodate that. I want to thank all of our partners here. We're going to conclude our conference with the much gratitude that we have, Clinic, and on behalf of our partners, for the Georgetown Law Center. Dean Trainer's remarks were just so spot on, and we're so grateful for the continuing commitment there. Our great partners at MPI really did the heavy lift this year, and we're so grateful to Lisa Dixon and many folks at MPI who really made it easy for us this year at Clinic, and all the staff at the Law Center, at Clinic, at MPI. We're grateful for you being here throughout the day to make this another successful conference. We do hope that you'll be back with us next year. The recording will be online if you miss sessions, so please make sure that you check it out, and we look forward to seeing you back next year. Thank you so much.